Good morning, this is your Kelso Report for Friday, June 15th, and I'm your host, Clark Kelso. We begin with a Ninth Circuit decision involving disability benefits and how you build an administrative record. In Bruce versus Commissioner of the Social Security Administration, the petitioner for Social Security disability benefits had submitted new evidence on his appeal to the Appeals Council from an ALJ decision denying his application for benefits. Now, pursuant to department regulations, petitioners are permitted to submit new and material evidence to the Appeals Council, and it requires the Council to consider that evidence in determining whether to review the ALJ's decision, so long as the evidence relates to the period on or before the ALJ's decision. Because the Council is required to consider the evidence according to their own regulations, the Ninth Circuit held this new evidence must be considered to be part of the administrative record. So when the court reviews the entire administrative record, it will include that new evidence that was submitted on the appeal to the Appeals Council. Well, when the Ninth Circuit reviewed the entire record, it held the ALJ had erroneously denied benefits and reversed and remanded for an award of benefits. But the important holding in the case is that that new evidence submitted to the Appeals Council becomes part of the administrative record. Next, we have a case arising under the Federal Sex Offender Registration and Notification Act, SORNA. In United States v. Elkins, the Ninth Circuit upheld the retrospective application of SORNA so that a juvenile who was committed of a sex offense prior to the enactment of SORNA still had to register once SORNA was enacted. The court reasoned that SORNA was not punitive, it was regulatory, and therefore was not subject to the ex post facto clause. Based on that holding, the court upheld the defendant's conviction for traveling in interstate commerce while knowingly failing to register under SORNA. Next, we have an eminent domain case arising in the Ninth Circuit in United States versus California State Lands Commission. The Ninth Circuit held that when the United States government pays just compensation to a state when exercising the power of eminent domain to secure fee simple title in a parcel of state land, the state does not retain any residual public trust interest in the land. The State Lands Commission had argued that the state retained some residual interest under either the public trust doctrine or the so-called equal footing doctrine. The Ninth Circuit rejected these arguments in light of, what else? The supremacy clause. Well, as a result, once the federal government has taken state property pursuant to eminent domain, it can reconvey it to someone else free and clear of California's public trust interest. Next, an important CEQA case from the California Supreme Court. In Tomlinson versus County of Alameda, the unanimous Supreme Court held that the usual exhaustion of administrative remedies rule applies to a public agency's determination that a project was categorically exempt from environmental requirements. Now, the developer had applied to a county planning department for approval to bid a housing subdivision. The department and the developer gave written notice to the various agencies involved, to neighbors and to interested parties. And the notice described the proposed project and mentioned the department's determination that the project was categorically exempt from certain environmental law requirements, and it solicited comments. Well, after holding the public hearings, the county determined that the proposed project was in fact categorically exempt, and they approved the project. When that approval was challenged in court, the developer objected that the plaintiff had failed to object to the department's determination that the project was categorically exempt during the public comment period. According to the exhaustion of remedies rule, an agency's approval of a proposed project can be challenged in court only on grounds that were presented to the public agency orally or in writing during the public comment period. or prior to the close of the public hearing on the project. The Supreme Court held that this rule, this exhaustion rule, applied to the determination of a categorical exemption. So the plaintiffs here were out of luck for failure to exhaust by presenting that objection to the public agency. Next, an important appellate jurisdiction decision in Oak Springs Villa Homeowners Association versus Advanced Trust Systems. The Second District held that a non-settling defendant may not appeal from a trial court's determination that a settlement between the plaintiff and other defendants in the case was reached in good faith. That determination is not a final order, and there's no separate provision in the CCP for taking an interlocutory appeal from such an order. Instead, Section 877.6e of the Code of Civil Procedure actually gives aggrieved parties 20 days after such an order has been entered to seek writ review. Now, the Second District's opinion is in conflict with the 2011 decision in Cahill versus San Diego Gas and Electric. So, this is an issue where we now have a conflict between circuit courts, and since this is an issue that will, I think, frequently arise, it would be appropriate for the Supreme Court to grant review and resolve the conflict in the authorities. We'll be watching to see if that's what happens with this case. And that's it for today's Kelso Report. Have a great day in the law and a good weekend. See you next week.